matter of HMRC and Malde and another.
Elizabeth, I see that you or someone else has sorted out the
Malone and Friend,
problems.
yes.
Thank you very much.
So those can go in the bundle.
Yeah.
We've also done a short note on King and Walden. I'll hand that in due course if I may. My email system didn't work immaculately this morning, so I want Malone and Friend to have a little more time to read it.
Yes.
We also have a further authority which is currently in a tax on its way here in hard copy. It's one in which Malone and Friend put forward the same arguments in the first tier tribunal earlier on this year that is advanced today, and the first tier tribunal found against him. So I thought it might give some assistance, particularly as it looked at the primacy of Article 6.2. So having said that, if I can go back to Sheldrake,
Yes.
because it is of some significance in the overall exercise, illustrating how it should be carried out in our respectful submission. Can I take you then to it's volume 1 of the authorities abundance, the very last one, divider 19. And if I could take you, please, first of all to page 274, which is paragraph 34. And I take you to this because it shows the circumstances or the legal background against which the derogation from Article 6.2 had to be considered. And as so often, there's a statute which, in parallel, we'd say to the present case, starts off with the necessity for the foundational facts to be proved and then a defence to be run when those facts have been established. So it was section 5.1b of the 1988 Road Traffic Act, and you'll see it letter D, provides if a person is in charge of a motor vehicle on a road or other public place after consuming so much alcohol, the proportion in his blood, etc., is guilty of an offence. So that has to be proved by the state. Then it's a defence for a person charged with an offence to prove that there was no real likelihood of him driving the vehicle. So that's the statutory background. Now, if we can go, please, on to page 294. There is a quotation there by Lord Bingham of Lord Staines's speech judgment in the case of the Queen against A, citation just at the bottom of page 293. And it is relevant, we submit, because it examines the force which the Human Rights Act has and the importance of guaranteed rights under the Convention. So reading at paragraph 44, starting just under the letter C, he said this: the white paper made clear that the obligation goes far beyond the rule, talking about reading down statutes, goes far beyond the rule which enabled the courts to take the Convention into account in resolving any ambiguity in legislative provisions. The draftsman of the Act had before him the slightly weaker model in Section 6 of the New Zealand Bill of Rights Act 1990, but preferred stronger language. Parliament specifically rejected the legislative model of requiring a reasonable interpretation. Section 3 places a duty on the court to strive to find a possible interpretation compatible with Convention rights. Under ordinary methods of interpretation, a court may depart from the language of the statute to avoid absurd consequences. Section 3 goes much further. Undoubtedly, a court must always look for contextual and purposes of interpretation. Section 3 is more radical in its effect. It's a general principle of the interpretation of legal instruments that the text is the primary source of interpretation, and other sources are subordinate to it. Section 3 qualifies this general principle because it requires a court to find an interpretation compatible with Convention rights if it's possible to do so. So the point we would draw from that is if the steer given to the courts and the requirement under Section 3 in terms of primary legislation is that strong, in relation to judge-made law, as it were, to the extent that we're dealing with judge-made law, then the same principles must apply. And if we go on to paragraph page 297, where he was reviewing the case of the Queen against Johnson, the citations to letter G on page 296, an offence under the Trademarks Act. So a person commits an offence when X happens, and then if we look at the defence provision, it's a defence for a person charged with an offence under this section to show he believed on reasonable grounds the use of the sign in the manner which used or was to be used was not an infringement of the registered trademark. So again, a statutory defence with the burden of proof on the defendant, but subsequent to the proof of the actual elements of the offence itself. And having described the Court of Appeal's decision, just below the letter C, Lord Bingham went on to say as follows: therefore, taking account of Sabalaiku and the interest to be struck between the public interest and the interest of the individual, it was for the state to justify the derogation and show the balance struck was reasonable. Identifying the requirements of a reasonable balance was not, he accepted, easy. Quote, all that can be said is that for a reverse burden of proof to be acceptable, there must be a compelling reason why it's fair and reasonable to deny the accused person the protection normally guaranteed to everyone by the presumption of innocence. The relevant factors to be taken into account when considering whether such a reason exists have been considered in several recent authorities, particularly the decisions of the House in Kibbeleen and Lambert. There's now a lengthening list of decisions of the Court of Appeal and other courts in respect of that particular statutory provision. Sorry, of respect of particular statutory provisions. A sound starting point is to remember that if an accused is required to prove a fact on the balance of probability to avoid conviction, this permits a conviction in spite of the fact-finding tribunal having a reasonable doubt as to the guilt of the accused.
We just pause there for a moment,
yes,
if you don't mind. Now that obviously applies in the core criminal context.
Yes.
Because there, when the Crown bear the burden of proof in a prosecution, the standard of proof is, well, today we say so as to be sure.
Yes.
That's traditionally understood to mean
beyond reasonable doubt. Yes.
So I get that, and I understand the Canadian decision in White, which is making the point that whenever you put the onus of proof on the defendant in a criminal case, the consequence may be that although there is a reasonable doubt about their guilt, they are convicted because they can't discharge the balance of proof.
Yes.
So the standard of proof, balance of proof.
Yes.
Now that doesn't apply in the tax context because, as we were hearing yesterday, it's common ground that the standard of proof is a balance of probabilities even when the onus is on the Crown.
Yes. Well,
So
yes.
That now doesn't apply, does it?
So that component, and I'll read the rest of the paragraph of me because it goes on to deal with burden of proof. We're not dealing with the standard of proof here. We're dealing with who has to prove the case. But if one stands back and looks at the reasoning there, which talks about the difficulties of a balance of probabilities and the possibility of an innocent person being convicted because he's not able to meet the requirement. In this case, the parallel is that a person, not the original taxpayer, is going to be found liable for very, very substantial penalties in circumstances of opprobrium without the basic facts having to be proved by the state. And
Are you leaving that paragraph?
now I was going to continue it,
Yes.
if I may.
Yeah.
This consequence of a reverse burden of proof should colour one's approach when evaluating the reasons why it's said that in the absence of a persuasive burden on the accused, the public interest will be prejudiced to an extent which justifies placing a persuasive burden on the accused. The more serious the punishment which may flow from conviction, the more compelling must be the reasons. So just pausing there again. I don't want to seem I'm harping on at it, but the consequences in this case are very, very serious. The extent and nature of the factual matters required to be proved by the accused and their importance relative to the matters required to be proved by the prosecution have to be taken into account. So also does the extent to which the burden on the accused relates to facts which they exist, are readily provable by him as matters within his own knowledge or to which he has ready access. So there is obviously an exercise, and we'll come to what we say the relevant matters to take into account in due course, but there's clearly an exercise which the court has to carry out to balance the competing factors, giving primacy, we would submit, to the fact that there is the Article 6.2 guarantee. And if I can just take you to paragraph, page 287 in this report.
Sorry, 287.
287 in the bundle.
Yeah.
It's
Yes.
page 292 of the report. If we can look at paragraph 9 at the letter H. There can be no doubt that the underlying rationale of the presumption in domestic law in the Convention is an essentially simple one, that it is repugnant to ordinary notions of fairness for a prosecutor to accuse a defendant of a crime, and for the defendant then to be required to disprove the accusation on pain of conviction and punishment if he fails to do so. The closer a legislative provision applies to that situation, the more objectionable it's likely to be. Now, again, it's dealing with terms of crime, and one can use the phrase core crime. But looking at the way the case was put from start to finish, looking at what was involved in terms of the consequences, we submit it's very difficult not to see this as very close to a pure crime situation, although it's against, of course, a tax background. So having looked at that, could I then look at the way in which the Upper Tribunal approached it in the present case? So we're going to the core bundle and page 350. Paragraph 103, which is page 103, thank you. So at paragraph 102, the court referred to Lord Justice Carnwath's analysis in Carn and said that it's not strictly binding upon us. We take due regard to the analysis set out in this judgment, but at least helpful guidance, and guidance which we should follow, particularly in relation to the burden of proof in the context of civil evasion penalties under section 60 VARTA. And we'll look at the development of the penalty regime shortly, which perhaps will put that into context. Paragraph 103, they refer to the general point. Lord Justice Conwell said the burden was on the taxpayer in both tax appeals and penalty appeals. These comments have to be read in their context, paragraph 2, namely that of an appeal against the civil evasion penalty under section 60. And this is an important concept that the Upper Tribunal grasped, that in fact his comments about the particular application of the burden of proof in that case were within a particular statutory context. In such a case, the statute is clear the burden falls on HMRC in relation to the intention to evade VAT and dishonesty. The clear implication that the burden of proof on other matters fell on the taxpayer. The point is acknowledged by Lord Justice Carnwath in his judgment. The other matters include the quantum of the underlying liability where the burden of proof fell on the taxpayer for all purposes, including for the purpose of the civil evasion penalty. Even so, as Lord Justice Carnwath acknowledges, in proving intention to evade VAT for the purpose of Section 60, HMRC must necessarily also prove the fact of evasion. Now, for the reasons we advanced yesterday, we submit that the fact of evasion is analogous to what has to be proved as a foundational fact in this case. Something must be proved for liability to attach to a taxpayer. For that reason, the burden was on HMRC to establish the VAT threshold had been exceeded, and by implication also the taxpayer had been made sufficient taxable supplies in order to exceed the relevant threshold. So, in the present case, in order to be liable to pay VAT and assessment, the company would have had to exceed the threshold on taxable supplies. And for the reasons we've already looked at, in order to be registrable in the first place or to attract duty, those supplies would have to be in the UK. So if we go to paragraph 104, the Upper Tribunal said this, as we mentioned above, this passage, that's the one from Carnwath, provides some support for the proposition that Mr Harehurst advances. However, the judgment has to be set in its context. Furthermore, as the Carnwath analysis acknowledges, any decision on where the burden of proof lies has to pay due regard to and be compatible with the presumption of innocence in Article 6. The reason that Justice Carnwath is able to come to view that the onus was on the taxpayer in relation to the quantum of tax liability was that the statute provided clear guidance as to where the burden should fall, and he was satisfied the requirements of Article 6.2 were met at least in part by the allocation of the burden in relation to issues of evasion and dishonesty to HMRC. In the usual case, an appeal against the imposition of penalty will take place against the background of an appeal against the tax liability to which it relates, as in the present case. The assessment of that liability will either have been finalised or will be determined as part of the same proceedings. The statements made regarding the burden of proof in many cases concerning penalty assessment will therefore often assume that the questions relating to the substantive liability have been settled. Such statements can properly regard as limited to the conditions that have to be fulfilled for the imposition of the penalty. For example, the conduct of the taxpayer and whether that conduct has brought about a tax loss. Paragraph 107, in a case where a taxpayer does challenge a penalty assessment on the grounds that the underlying tax assessment is wrong, an estoppel or abuse of law doesn't arise, there's a potential conflict between the two general rules to which we referred governing the burden of proof in tax appeals and the burden of proof in penalty appeals. This is particularly acute where the underlying assessment has not been subject to litigation, in the present case. So they then went on to look at the case of Zahn, which was obviously a relatively recent decision. And one or two things need to be said in relation to Zahn, which in our submission show that appropriate caution is needed. Firstly, the taxpayer was unrepresented. And secondly, as the upper tier tribunal in the case that we're looking at currently said, paragraph 111, there was no reference to Article 6. There was no reference to the various cases which have considered Article 6. And they came to the conclusion, adopting, it seems to us, the interpretation of the requirement for the revenue to prove the fact of evasion, that they adopted that interpretation of what Lord Carnwath said. We would submit that that is the best way to reconcile what he said in Carn with Article 6.2, i.e. the underlying assumption that the proof of evasion, which inevitably involves proof of the underlying tax liability, was a matter which lay with the state.
Sorry, can you just say that again?
Yes. What they said here is the practical effect of the decision of the Upper Tribunal in Zaman appears inconsistent with the guidance of Conworth in Khan, albeit a different statutory context, in that Conworth accepted that some essential elements of underlying tax liability, i.e. whether the threshold was exceeded, were part of the issue of evasion and for HMRC to prove.
So we're in paragraph 111.
Paragraph 111.
So the Upper Tribunal thinks that Zaman is inconsistent with Lord Justice Carnwath in
Yes.
Khan.
Or perhaps one might say a superficial reading of it. But in any event, in Zaman what had to be done wasn't done, i.e. Article 6.2 and how to deal with the balancing exercise. So at paragraph 112, the Upper Tribunal said this, and we submit that this was absolutely accurate. Having reviewed the authorities, in our view, the key cases, principally King v Walden and Euro Wines, are clear that the question of the scope of the burden of proof in penalty appeals must be determined by reference to the application of the presumption of innocence in Article 6.2. On that basis, the burden must fall on HMRC in penalty appeals unless an exception to the presumption can be justified. We submit that comes clearly out of the European case, it comes out of Sheldrake, it's beyond argument, we would submit. Whether or not exception can be justified will depend upon all the facts and circumstances of the case. The penalty appeal, in which the penalty is challenged on the basis that the underlying assessment is wrong, once questions of stop or abusive process have been addressed, remains a penalty appeal. As such, and as a general rule, the principle the burden is upon HMRC in penalty appeals includes a penalty appeal of this kind. That is to say, a penalty appeal where the challenge is made on the basis that the underlying assessment is wrong. And we say that in order to derogate from the broader protection given by Article 6.2, given the criminal nature of the penalty and given the highly criminal nature of what was alleged against Mr Malde, but in those circumstances, the Upper Tier Tribunal was right to say, well, we've had effectively nothing here to suggest that it's appropriate to displace the Article 6.2 presumption, and therefore it should apply. We will go on to submit that in any event, there are good reasons why the Article 6.2 presumption shouldn't be ousted in this type of case, but that's a separate point I'll move on to, if I may. Now, my learned friend cited a number of other cases which were rather seen as perhaps not being particularly helpful, in which Zaman was followed by the first tier tribunal, but of course the FTTs were subsequently bound by it, and we say they had nothing by way of illumination. It was suggested that some help in terms of splitting up issues could be gained from the case of Nasdimos, but we said that's of little illumination. The FTT found in that case that where there was an appeal against penalties, but not against an underlying assessment, the underlying assessment was not binding, but then they were looking at it through the prism of best judgment. And so, if I may, to the legislative history of the current provisions, which in our respect submission do give good illumination as to why the burden of proof of the principal fact should be upon the revenue. The history was looked in the case of Hahn, which is in the authorities bundle behind volume 4, the first tab, page 966. This was a case from 2001. So now some time ago, and it was looking at the evolution of the penalty regime. So it's illuminating. And if we can look at paragraph 37 of the judgment, which we can find at page 976. They set out the history to date. The genesis of the civil penalty code for VAT to be found in the 1983 Keith report. At the time of the inquiry, the VAT offence code was set out in section 38 of Finance Act 1972. It provided solely for criminal offences, and no civil penalties were provided for fraud or negligent acts or omissions of a lesser kind. Obviously, that was found to be difficult by customs and excise as they were at that time, and they were discontent with the fact that it effectively was a criminal prosecution or nothing. The Keith report at paragraph 39 noted this position. Such arrangements were contrasted with those available to the Inland Revenue in respect of tax, where civil penalties were provided both for regulatory matters and a wide range of offences such as neglect and fraud on proof to the civil standard. Criminal proceedings under the mainstream criminal law were taken only in respect of heinous cases of fraud. It was strongly desirable that there should be harmonisation of offence arrangements for VAT. Top of page 977, the department told us that given accepts the need for a regulatory sanction, it could certainly envisage a system of civil sanctions operating much the same way as that of the Inland Revenue, the civil penalties structured as were the existing criminal ones. Paragraph 14, dealing with the suggestion of the introduction of a single penalty code, the report recorded as follows. Turning to the question of the introduction of penalties of civil fraud to run in parallel with the bringing and compounding of criminal proceedings, Customs and Excise told us that the run of the two systems together would undoubtedly give much greater flexibility in dealing with fraud or near fraud. It would afford welcome assistance in dealing with those cases where there were indications of fraud but where it was not possible to obtain proof to the criminal standard. At present, those cases finished a simple unpenalised assessment and represented a loss to the Exchequer. We go to paragraph 43. So far as fraud and dishonesty were concerned, the report noted that the requirements that fraud had to be proved to the criminal standard before penalties could be exacted meant that many large understatements arising through lack of demonstrable care. And if I can then go on, please, to page 978. So I've been there. Yes, sorry, 978 at letter C. Again, the focus is on a civil burden of proof, not a reverse burden on the taxpayer. Welcome our witnesses heard no consistent body of criticism of the lower civil burden of proof in such cases as being unfair to the taxpayer. We conclude that a new default should be introduced into VAT law, and we use the term civil fraud to distinguish it from similar dishonest conduct prosecuted in the criminal courts. At paragraph 48, Before us, the parties emphasise various features of the Civil Penalty Code introduced by the Value Added Tax Act. In the following list, the Commission has emphasised points and sets out various points. The ones emphasised by the Commissions include this. Section 64A expressly refers to the amount of duty by way of a civil penalty. Such penalties were provided for as a deliberate decriminalisation of the VAT and duty penalty scheme. There are alternatives to criminal penalties which are available in more serious cases. The taxpayer is dealt with by means of a civil procedure subject to the lower burden of proof, balance of probability, and avoids the stigma of criminal conviction. Of course, at this stage, they're talking about fraud and noted the penalties require a finding of dishonesty. So that refers to effectively what Section 60 was providing in terms of dishonesty and fraud, which we've already looked at. But then the legislation moved on. Schedule 24 was introduced by the Finance Act 2007 and expressly replaced the Taxes Management Act, Value Added Tax Act penalty schemes. Paragraph 1 of Schedule 24.
Should we turn that up?
Sorry?
Should we turn that up? Or
Yes, I think well, it's Authorities Bundle, page 96.
Yep.
We looked at it in part yesterday, but I just want to look a little further down in detail. So this is for errors in taxpayers' documents. So this is where they submit a document, but there's an error in it. And we looked yesterday, conditions 1 or 2 having to be satisfied. Condition 2 is that condition 1 is the document contains an inaccuracy, which we said is the foundation for liability. Condition 2 is that the inaccuracy was careless or deliberate on the taxpayer's part. So just looking at that, it's hard to envisage circumstances in which an inaccuracy is either not deliberate or not careless. And so there's no real distinction drawn between it. It's difficult to see a more basic form of inaccuracy than a careless one. And so deliberate and careless here come within the same regime. And interestingly, just to underline, as it were, the criminal nature of the penalty, it's divorced from actual revenue, is that where a document contains more than one inaccuracy, a penalty is payable for each inaccuracy. And indeed, further provisions provide that if other people are involved in inaccuracy, there's a separate penalty for each of the persons involved. So we then go on to Schedule 41, page 175 of the same bundle, which in terms of tabs is behind tab 14.
And that's in the next year's Finance Act, 2008, is that right?
2008, yes. So it was an extension of the regime to failure to notify and things of that sort. So at page 175 we have Schedule 41, paragraph 1, a penalty is payable by a person where the person fails to comply with the obligations. And for value added tax, for example, look at the foot of the page, obligations to notify a liability register and notify material change in circumstances. Now, what is particularly important we submit in deciding but understanding how the burden of proof was regarded, supported as it was by explanatory notes, consultation paper, and the Customs and Excise own guidance, is if we go to page 216, we find this. Paragraph 20. Liability to a penalty under any of paragraphs 1, 2, 3, 1 and 4, clearly relevant to this case, does not arise in relation to an act or failure which is not deliberate if the taxpayer satisfied HMRC or, on an appeal notified to the tribunal that there's reasonable excuse for the act or failure. So we would submit that a great deal of assistance can be derived from the fact that under Schedule 41, there is clearly, it's the inescapable inference to be drawn from paragraph 20 here, there's a primary burden upon HMRC that the condition is satisfied, i.e. a failure to notify, but then there's a reasonable excuse, the burden of proof being on the taxpayer. And we submit that that is reasonable because the primary facts have been established.
So just to understand how they relate to each other, under Schedule 24 of the 2007 Act,
Yes.
it has to be proved that the inaccuracy was careless or deliberate.
Yes.
For the purposes of Schedule 41 to the 2008 Act, the taxpayer has to prove that they have a reasonable excuse.
For not having done.
If it's not a deliberate penalty.
So liability to a penalty.
It is not a deliberate penalty.
Yes,
There
it's not,
is
yes,
also-
yes, they have to satisfy the tribunal on the.
It might help if we take one of the examples of what one of the appeals in the present case concerned, which is whether there was a liability to be registered.
Yes.
That's one of the things that you have to notify of at page 175.
Yes.
I think your submission is that before one gets to any question of deliberateness or any question of reasonable excuse, there is the question of whether the taxpayer was under a liability to register.
Yes.
You say, reading this legislation as a whole, the onus of proof on that prior question falls upon HMRC.
Indeed so.
And I think what you're saying is that's irrespective of anything to do with Article 6.2. This is just a matter of ordinary construction of domestic legislation.
Well, it is, yes. Certainly for this particular schedule 41, it's not expressly dealt with in terms of a reverse burden in schedule 24, but there is a requirement to prove in Schedule 24 carelessness or deliberate.
Sorry, I'm dealing with Schedule 41.
Yes, well, yes, well, both are engaged in the present case. This is, yes, Schedule 41 here.
Yeah.
Yes.
Yeah.
So can I just sort of talk around it for one moment? So Schedule 24, there has to be an inaccuracy. And however that is to be proved, or whoever is to prove it, the revenue have to prove that it was careless or deliberate.
Yes.
Schedule 41, there has to have been a failure to notify. There has to have been a liability to notify.
Yes.
Assuming that one way or another is taken as the case, then you're into paragraph 20.
Yes.
Now, where the failure was not deliberate, the taxpayer can prove that there was a reasonable excuse. So to that extent, the burden is on the taxpayer. Who has the burden on deliberateness?
We would say the revenue, because reasonable excuse for an act of failure, an excuse means something which justifies something which has or has not been done. The act or failure itself must be proved as a foundation fact by the revenue.
And I followed that, but in
Yes.
terms of the deliberate or reasonable excuse bit,
Yes.
plainly, because of this provision, the burden is on the taxpayer to prove the reasonable excuse.
Yes.
But that only applies if it's not deliberate. So is the burden on the revenue to prove that it is deliberate?
Yes.
Paragraph 5. Paragraph 5. They would have got to.
I'm having paragraph 5 listed.
Which is probably the clear answer.
Eight.
This is the leads into 6, doesn't it?
So before they get to reasonable excuse.
So I think we go to page 185, and so this is the context in which I think the word deliberate is used.
And that leads into 187, which is the levels of penalty.
Yes.
Now, so if the revenue want to say to assess on the basis it's a deliberate or concealed failure, plainly the burden is on them.
Yes.
If they simply assess it on a C basis, so they're not at that stage alleging deliberateness or concealment, then I suppose
They're alleging negligence.
you're simply into, well, they're not alleging anything, they're just saying it happened,
Yes.
and then the taxpayer has the defence under paragraph 20.
Yes. But as my Lord rightly says, the revenue is saying it happened.
Yeah, no, quite. No,
It's
I
saying
mean,
it's happened.
for all these things, whoever has the burden, or
Yes.
however the burden is to be discharged, there has to be an initial inaccuracy or failure to register when you ought to have done.
Yes.
Yeah.
And our whole point is that has to be proved by the state before we actually get on to anything else, because the foundational requirements which give HMRC jurisdiction to issue penalties are entirely dependent upon the occurrence of certain facts which must be proved. Otherwise, the repugnance which was mentioned by Lord Bingham in Sheldrake surely would operate. The concept that simply by making the assertion that penalties can be imposed upon someone unless he can prove that there was no liability tax in the first place is in our respectful submission. It is something which most people would have a difficulty in coming to terms with for very good reasons, that it offends one's basic sense of fairness.
Now, by the time either of these pieces of legislation was enacted, Khan had been decided. You took us yesterday to materials predating or the explanatory notes
Yes.
in relation to the legislation. I don't remember any reference to Khan. Is there anywhere any reference to Khan
In terms of the notes, etc.
in terms of the legislative history or explanatory notes? No.
No.
Yeah.
And we looked at the explanatory notes, but just for your note, from the explanatory notes, which are at page 1258 of the authorities bundle, described as creating a single legal framework for penalising failure based on the same principles in Schedule 24. So clearly, the Schedules 24 and 41 were seen as part of a single legal framework. And sorry, I'll take you actually page 1258 if I mind.
Yeah.
Sorry, which volume bundle are we in?
It's in volume 4 and it's behind tab 54. No, it isn't.
65.
65, tab 65. paragraph 2, at page 1258, specifically said, under the new regime, a penalty would be payable in any case where the notification obligation had not been complied with. So there's the trigger, and tax has been lost as a result, other than where the taxpayer could show they had a reasonable excuse for failure. So that is seen as across the piece, according to the explanatory notes.
Yeah.
And finally, just dealing with how the burden of proof and how the case should be assembled, at page 1275 at paragraph 94, again in the explanatory note. The schedule provides a penalty would be payable if a person fails to comply with an obligation to notify HMRC that they are liable to tax. The tax has been lost as a result. The framework takes into account the behaviour of the taxpayer by having 3 categories of failure, which we've seen. The 2 more serious ones are modelled on those for inaccurate returns, deliberate and concealed, and deliberate without concealment. In both cases, a penalty would only be charged where HMRC have strong evidence to demonstrate the behaviour to a high degree of probability. Well, again, it rather suggests that a lesser standard of proof might be required for non-deliberate and concealed, etc. But nevertheless, it's not suggested there that there's any burden upon the taxpayer in relation to the foundational facts. So we submit that if Parliament had intended to reverse the position which had been long-standing under the Taxes Management Act and the Value Added Tax Act, they would have expressly said so in the statute.
Well, one might turn that round and say, if Parliament had intended something different from Khan, they'd have said so.
Well, the operation of the regime over a long period and the discussion of it in the framework of a civil burden of proof, which we saw reviewed in Hahn, would rather suggest that that would be placing more weight on Khan than perhaps it could realistically be asked to bear.
So, rightly or wrongly, Lord Justice Carnworth seems to think that he's talking about what has been generally understood to be the position.
Although he did it in the framework of cited in Authority 2 planning appeals.
He did, yes.
Article 6 is a rather different creature. Can I now look at the question of separability? As already noted, the whole basis upon which this is now approached wasn't that which was suggested by the appellants in the first tier tribunal. We accept, however, that there will be cases where separability is appropriate. And if we look at what the issues in Omar Minerals was, we can see how different they were to the present case. So that's Authorities Bundle 1, behind divider 18, page 240. Now this was an assessment followed by a penalty in relation to the nature of rock removed from the appellant's open cast gold mine. If we look at paragraph 2, the issue is defined by the tribunal in these terms. Essentially, HMRC contends that the rock consisted of mica, schist and quartz, i.e. rock which isn't exempt from aggregates levy. The appellant, on the other hand, says the rock consisted of shale or slate, and therefore an exemption applied. If we go to paragraph, page 257, we can see here the chairman of the first tier tribunal, looking at Georgiou and looking at what guidance was given about being able to separate different issues out. He said this: "I accept, however, there may be cases, as the court observed in Georgiou, where the incidence of liability in respect of the penalty is so intimately linked to the manner in which the substantive liability to tax arose that the two proceedings cannot be separated. That consequently, the consideration of the proceedings in relation to a criminal charge must to some extent involve consideration of the substantive tax assessment. Thus, in Georgiou, the penalty proceedings required a finding of dishonesty after the consideration of extensive evidence at the hearing spanning 49 days. Length of hearing seems a bit familiar in the present case. Evidence which related to the assessment and penalty in that context, the court's observations concerning the difficulty of separating the proceedings were entirely understandable. This appeal is very different. Here, the main issue is whether the rock extracted by the appellant was exempt from aggregates levy. That is the main issue in the assessment appeal. So we submit there is a very, very great difference between circumstances typified in Omar, where there's a simple issue: what sort of rock was it? In the present case,
Can I just be clear on one point that isn't entirely unconnected with this? So if you have a case where the revenue assess someone to tax and they impose a penalty, and someone appeals both and they're dealt with at the same time, what burden of proof applies in relation to the appeal against the assessment?
we would analyse the case in Omar to assist in exemplifying or giving an example to answer my Lord's question. We would say the fact that they had rock and were handling rock was not an issue, and therefore basic foundational fact. And then obviously the analysis of what the rock was. On one view, one might say, well, that is a foundational fact which the revenue should have proved. And I'd have sympathy with that view. But I'm citing the case on the slightly different issue, and I understand why my Lord asked the question on the different issue about separability.
And I see that, but just pursuing it a moment longer, forget about a rock case.
Yes.
Have simply a case where the revenue think that some trader hasn't been declaring their supplies.
Yes.
And they assess and they impose a penalty, and they come before a tribunal together. Now, conventionally, the appeal against the assessment would definitely involve the burden being on the taxpayer. Now, when the tribunal is dealing with both together, on your case, does it apply that burden when dealing with the assessment and a different burden when dealing with the penalty? Or does it apply the burden it would apply on your case in relation to the penalty in relation to the assessment as well?
That second proposition, it applies to both elements.
So
Yes.
If both come together before a tribunal,
Yes.
the tribunal has to apply has to say that the burden is on the revenue in relation to everything.
Yes, I would say so. And we would submit very good principal reason why that should be the case. In an assessment, one is assessing a civil liability, essentially for a debt. Whereas, in terms of a penalty, one is going further and imposing a criminal penalty, as decided by the courts on many occasions now, which can, as we see, you can go up to 200% of the revenue which is said to be lost. And so as a matter of principle, we would submit that the foundational elements have to be proved by the state before the state can ask for penalties to be imposed.
So the taxpayer gets the benefit of that principle in relation to the assessment.
Yes, No, not in relation to, well, yes, if it's both things being heard at once, yes.
Yeah.
Now, I accept that the fact that a different burden may apply depending whether or not there is a penalty or not, and therefore, as it were, there's sort of parasitic advantage to the taxpayer if there has been a penalty, may not be a comfortable position when one stands back and thinks, well, there is an inconsistency there. But where an assessment has been made, the consequences are very different from a penalty. And therefore, one can see why it's reasonable to say, well, I'm afraid because of the extra weight here, it all stands or falls together, and that is just a feature of the system.
What I'm unclear about is why one should not be able to do an operation of severance in these circumstances, precisely to avoid this uncomfortable conclusion, which, as a matter of common sense, does seem uncomfortable and not something you wouldn't wish to end up with unless you really have to. And I mean, the obvious way around it is to say, surely, that the assessment phase of the exercise is logically different and prior to the penalty. And in looking at that earlier, prior part of the exercise, why should one not follow the normal rule, which is that the burden is on the taxpayer to displace an assessment?
Because they're different beasts.
Well, I mean,
Simply.
doesn't that rather beg the question? Of course they're different beasts, but the issue is whether, because of that difference, one therefore has to place the criminal burden of proof on the revenue in relation to an assessment which would not normally be subject to it.
No, because the penalty is not the assessment.
No.
The penalty is based on the revenue at risk. It's usually quantified by an assessment, but an assessment is not sufficient to prove the penalty, and because what one might divide in this way, possibly, the assessment stands, but when deciding whether a penalty is payable, the assessment's looked at de novo. But we submit that that isn't the way in which it was approached in this case. In this case, there was never any suggestion that they should be dealt with separately. It's rather harsh to criticise the FTT for doing that, which it was asked to do.
I mean, we've got to try and work out what the right answer
Yes,
is.
I
Question
appreciate
the burden of proof, it's a legal burden, and you know, either you're right or you're wrong. But
Yes.
But the obvious attraction in the revenues case, at least as it looks to me at the moment, is that it gets round the inconsistency you would otherwise encounter between giving it, as it were, giving the taxpayer when he's being submitted to a penalty, when he's been made liable to a penalty, he gets a kind of leg up which he wouldn't have in the context of the liability assessment.
that may be a regrettable consequence in this limited set of cases for the revenue.
Well, it's not
One
so-
has to, sorry, my lord, one has to weigh against that the derogation from Article 6.2.
Well, I mean, that's a big question, isn't
Yes.
it? Is whether it's a
Yes.
permissible derogation from Article 6, given that we're not here in the core criminal sphere, but in a sort of penumbra.
Yes, we're much closer to the core criminal scheme on the facts of this case, as it was run right from the start, than many of the things where we're talking about minor penalties, etc., £2,000, £3,000, £4,000,
Yeah.
where the balancing exercises come out rather differently, and therefore one does get back to what Lord Bingham said in Sheldrake, that you've got to look at each situation on its merits.
You're right, of course, about that. But do you accept that, so far as Strasbourg is concerned, Article 6 simply doesn't apply to the ordinary assessment?
No, Ferrazini says that matters of tax are pure matters of tax. So it doesn't, but then we're not talking about tax, we're talking about penalties here.
I mean, you're obviously right, and I quite follow your emphasis on the scale of what's demanded here.
Yes.
But were Global to have lots of money, it would be just as severe from Global's point of view. It would be landed with this enormous liability.
Yes.
Um,
That would be a tax liability by assessment. Well, they'd have, if setting aside the penalty, they'd have to appeal it.
And then the burden would be on them,
Yes.
even though it's a lot of money.
Yes.
And they would have to pay the tax up front too.
Which was the problem in this case. Of course, they couldn't.
Anyway,
So they were precluded from doing so. So I suppose, looking at it from another angle, where a taxpayer has been precluded from mounting what may be a legitimate challenge to an assessment because of a lack of funds, one might say that the ability to review that position and review liability in a penalty appeal is not an unreasonable alternative.
why should that give them the benefit of a different burden of proof when effectively that part of the exercise is completely standard and is obviously covered 100% by Ferrettini?
Yes, well, because I'm concerned with the burden of proof for penalties. The expression was used on a number of occasions by Mr Hayhurst of talking about passporting through assessment. And we submit that that's a really unhelpful way of looking at it, except that it shows what HMRC is really after. They want it to be a done deal on which the burden of proof is always going to be on the taxpayer or the non-taxpayer in the case of Mr Malde, because he's not the taxable person.
Well, that is true. On the other hand,
Yes.
from a slightly one stands back and looks at the position as a whole, one can see the logic of a taxation system which would enable the revenue to try and recover the money from the controlling figure who's run the whole show.
My lord, of course, and that's why in one or two of the European cases we've looked at, one of the things examined by the European Court was whether it was, I think the Swedish case, whether it was reasonable to have a penalty system.
Yeah.
That doesn't answer the question about where the burden of proof should be. I don't for a moment suggest that there shouldn't be a penalty system.
Yeah.
I don't suggest that where the relevant proof is available, persons behind companies should not be liable to personal liability. Well, all that's given, but it's a different question. And I can understand the arguments that suggest that, well, that there is a public interest in collecting this money, and I understand that. But there's the balance. There's the balance. And we submit that the balance is very firmly on the side of Article 6.2.
On the other hand, I think you obviously do accept that there definitely can be, and indeed are cases, where the kind of separation or severance envisaged in the Priscilla case is appropriate. And in such a case, Article 6, in fact, is not engaged at all, because, isn't that right?
It's not engaged into the assessment element of it.
Well, not engaged in relation to the assessment element, in relation to which normal principles, this seems a reasonable starting point.
Yes.
Normal principles should apply, and this is some compelling reason why they shouldn't.
So we have Georgia, which we just looked at, cited in paragraph 62 of the judgment in Omar, which makes it clear, and this was the next thing I was going to come on to, that in some cases you simply can't comb them out. And our submission is this is preeminently one of them. So as in Georgia, the evidence in the present case is complicated. It spanned many weeks, having to be examined with issues of dishonesty, statutory burdens of proof under section 1661, what was the appropriate burden of proof under European and other domestic legislation, the necessary allegation that Global was supplying in the UK as part of a huge smuggling operation, the whole case being predicated on the basis that Global was just one company controlled by Mr Malde, and that he placed buffers between Global and the UK. Multi-jurisdictional evidence. It presents a very stark contrast to the issues in Omar, identified at paragraph 63 of the judgment. And it is clear that there were a number of different things which the tribunal had to consider in the overall allegation of organised crimes. And it was multifactorial with different statutes, some silent as burden of proof, others not silent as burden of proof, and so forth. Now, in those circumstances, to say that you can tease it out is, in our respectful submission, just unrealistic. It was not a realistic prospect, which is presumably why the appellants agreed that the approach that the tribunal should take was the appropriate one. And so, looking at Georgia, we submit the guidance given there, and it's obviously you've looked at other cases with this, but where the issues are ineluctably overlapping and joining each other, it's not possible to separate the proceedings into little separate.
Have we actually looked at Georgia?
Yes, we looked at it in Malone and Friends
We
submissions.
did we?
We'll look at it again, though, very happily. Because I know we've looked at so many cases that sometimes they become blurred. It's at volume 2.
I mean, I remember a reference to Georgia. I can't actually remember looking at it, but we probably did.
Tab 22, page 375.
I'd say it's, yes, I see. I'm sure we did look at this. 'Cause
You
I've marked it. It was
recognise
383, yes.
Mario's chippery.
Yes.
So you recognise that. So unless you want me to.
No,
go
no,
through
no,
it again.
no. It's just, I'd forgotten.
Oh, go on. Yes.
I think it's worth looking on Georgia. 380. Complaint.
Yeah.
Yeah. Okay. So
Equally, it's not enough, is it? I mean, just to say, liability appeal involved a lot of complication and involved allegations of fraud, which in the event weren't established, because all that is something one has to accept in a standard case with no penalty involved at all. So again, I end up asking rhetorically, well, why should it make all the difference and give the person upon whom the penalty is imposed the second run at all of that complex factual background is a very difficult standard of proof.
Well, in this case, it wasn't, of course, a second run.
It wasn't, but in
But
most
I'm not merely making. I wasn't merely submitting that it was complicated factually, etc. I was saying there were different provisions, different statutory burdens, provisions relating to the burden of proof. Very complicated evidence, and as such, looking at Georgia. But it simply can't reasonably, a tribunal couldn't reasonably disentangle it. Yes, and of course the penalty conditions, the penalties were issued on the basis of deliberate and concealed.
yeah. Of course, Georgia did go on to the European Court, didn't it? Right, so that's next.
It did.
This is the
This is the European Court.
Yes.
It looks like an English report.
Sorry, this is the English one, that's right.
This is the
I'm forgetting it.
I'm glad I'm not the only one forgetting the detail of the authorities.
I think the issues in this case would lead anyone to go and lie down in a dark room for a while.
Yes.
It would be nice to have the luxury to do so.
On the whole, I mean, the judgment, yes, of course, they found it was a case where severance is not possible, but it doesn't go very far in providing a reasoned basis for that conclusion, rather than just accepting it in rather bold terms on page 383. And tell me if I'm wrong, but I don't think there's any passage which really expands on that part of the analysis.
No, but it's what the court has to apply.
Indeed.
So it's the principle.
Well, the principle is you don't sever if it's not possible to do so. That
Yes.
raises the next question: by what criteria do you determine whether it's not possible to do a severance? And I suppose one's back into the area of multilateral assessments. Consideration.
I don't know whether if one looked at the English reports, one would find out more about what had gone on.
I think that there's probably would it help if I read the headnote because it does set out the history of it. Page 375. The applicants owned a takeaway food shop. In early 1990, following investigation by the customs officers, the applicants admitted they'd undeclared the shop's takings. Just pause there. So the basic facts there are admitted. Removing cash from its till and withheld purchase invoices. So we're talking about quantum in effect. Assessments were made on the applicants in respect of undeclared output tax based on a weekly suppression rate derived from the till grand total. The applicants asked the Commissioner to reconsider the assessments. And in November 90, amended assessments were issued for a reduced amount of undeclared output tax. In December 1990, a notice of assessment to penalty was issued against the applicants for dishonest evasion of VAT. They appealed against the amended assessments and against the penalty assessments. The Tribunal heard the appeal over 49 working days from March to July 93. 24th of April, it dismissed the applicant's appeal. The High Court affirmed the Tribunal's decision, Court of Appeal dismissed, refused to move to appeal, and then applied to the ECHR. They were complaining about grant of legal aid, denied access to a number of relevant documents. It had taken a long time for the decision to come, and if one looks at just above letter D, the applicants further contended that the manner in which the assessments were reviewed by the commissioners, subsequently by the Tribunal in 1991, constitutes a violation of their rights under Article 1 of Protocol 1 to the Convention, which provided inter alia every person is entitled to peaceful enjoyment of his possessions, and there also wasn't an effective remedy. But then the court looked at.
I was looking on. Just what what did they say had gone wrong in Article 6 terms?
In Article 6 terms, sorry, it's my fault.
They hadn't been allowed legal aid.
Yes, they
hadn't been denied access
legal
to
aid,
some documents.
denied access, and
delay.
delay. Yes.
So, in a sense, the inability to separate point arose in circumstances where they're saying, look, we have to deal with this matter as within the scope of Article 6, which they obviously did have to do, because when you're considering whether there's been delay, you don't say, well, there's been no delay in relation to, it doesn't matter if there's delay in relation to the assessment, but it does matter that there's delay in relation to the penalty or whatever.
The whole period.
So it's not really quite our situation.
It isn't quite our situation, but they do nevertheless go on to say what they say at page 387, letters G to H.
383 G to H.
383.
Yep. Yes.
As to whether the assessments themselves should also be seen as criminal charges for the purpose of Article 6 guarantees, the applicants argue that since the penal proceedings rely on the assessments for their validity, it would be wrong not to look at the proceedings as a whole. The court accepts it's not possible, given the various matters which are being determined by the tribunal, to separate those parts of the proceedings which determine a criminal charge from those parts which didn't.
But you might say, well, look, we understand that the tax assessments aren't within Article 6 at all. But what we're dealing with here is complaints that people aren't allowed legal aid or the decision took too long, where some of what's at issue plainly was within the scope of Article 6, and we can't then separate them out. and that makes sense.
But that makes sense, but we say the same must apply to issues where there are multiple issues which have different tests to apply to them, etc. And where liability, we go back to the original point, liability depends upon some foundational facts to be established.
It may be of some interest that there's a very helpful chronological list of the authorities that the parties have given us.
Yes.
Yes.
And I'm just looking at the first pages. Georgiou was decided in May 2000. First,
No, you said it hadn't been decided yet.
Thingy is Grand Chamber, so not just a chamber
Yes.
or section. That's July 2001. Although no doubt the issue had been foreshadowed, I suspect, in earlier Strasbourg case law, because there's not a new problem about whether tax appeals fall within Article 6 at all. But nevertheless, the Grand Chamber judgment doesn't come until about a year later. And I also, looking at the chronology, also found it interesting that Janosevich is 2002. So it was before the decision in Khan, although as we've seen yesterday, Khan didn't refer to any of these Strasbourg cases. But Khan predates Usilla,
Yes.
which is November 2006. I only draw attention to that chronology in case it's of any importance. Certainly speaking for myself only, I find it of some interest, but whether it's legally relevant, I'm not sure. It may be, in this sense, that Section 2 of the Human Rights Act requires the courts of this country to take into account any relevant decision of the European
Yes.
Court of Human Rights. And obviously, since Usilla had not yet been decided, this court could not take it into account when it decided Khan.
Yes, well, we looked at Gisela and it was considered in some detail, if I remember rightly, in Euro wines.
Yes.
And we derived, I hope, some assistance from that analysis in Euro wines. And as my lord said, I think yesterday or the day before, Euro wines, of course, is a court of appeal authority and binding on the court unless it's obiter or per incuriam.
I'm just looking at
Perhaps,
Drusilla,
yes,
Drusilla, however it's pronounced.
right. Drusilla is volume
20.
2, tab 20, page 323.
I'm not sure what it adds to the previous authority.
It does, certainly Mr. Hayhurst, I think, placed emphasis on some passages at page 333 of the bond.
Yes,
One is that tax surcharges differ from the hard core of criminal law.
that's true.
And the second thing I think he was deriving, or at least seeking to derive from this, is that although it may not be possible to separate parts of a penalty charge, see Georgiou, the converse seems to follow that it may be possible.
Yes.
And of course, by this stage, they have the advantage of Ferrezzini, which they refer to at paragraph 45.
Yes.
Could I just, whilst we're here then, just draw your attention to page, to paragraph 36 at page 331. So this is relevant to the issue about whether one can, I'm going to use the word, derogate from Article 6.2. Furthermore, the court is not persuaded that the nature of tax surcharge proceedings is such that they fall or should fall outside the protection of Article 6. Arguments to that effect have also failed in the context of prison disciplinary and minor track offences. Whilst there's no doubt as to the importance of tax, the effective functioning of the state, the court is not convinced that removing procedural safeguards in the imposition of punitive penalties in that sphere is necessary to maintain the efficacy of the fiscal system, or indeed can be regarded as consonant with the spirit and purpose of the convention. So in a sense, my Lord Justice Henderson, the points being raised where you have to grapple with what's said there.
Yeah.
And it's not, I concede freely, it's not easy. And clearly the number of cases I've had to consider these points rather reflects that fact. But again, that may be a function of the necessity to look at each case on its merit.
Yeah, and we took you out of your course, I think.
No, right. As long as I wasn't heading straight for the rocks, I'm fairly happy as that. I just need to deal briefly with the case of King against the UK, which is Authorities Bundle Volume 2, page 455, behind tab 26. And just that my learned friend read from, if my recollection is right, the court's assessment at line B at page 464, sorry, page 464. About the existence of a criminal charge, and again, these lines underline why the burden of proof is important. It's important to maintain Article 6.2, we would submit. The court would note, first of all, the procedures concerning the assessment of tax owned by the applicant fall outside the scope of Article 6.1 as neither concerning the determination of a criminal charge or any of the applicant's civil rights or obligations, citing Ferrezzini. However, as regards the imposition of penalties calculated as a percentage of the unpaid tax, the court considers these cannot be regarded as pecuniary compensation for any costs that may have been incurred as a result of the taxpayer's conduct. Their main purpose is to exert pressure on taxpayers to comply with their legal obligations and punish breaches of those obligations. The same elements may be identified in this case as in Janasevic, Vastberger, which found the imposition of tax charges of up to 40% for the avoidance of tax fell within the scope of Article 6. Of course, they're 100% in this case. As in those cases, the court does not consider it decisive that a sentence of imprisonment wasn't at stake. While the government asserted the procedure was classified as civil, the court notes the domestic courts themselves appear to have no doubt that they should be regarded as criminal for the purpose of examination under Article 6.1. So just really going back to what's in the earlier part of that paragraph, underlining this is in no way compensation for costs that may have been incurred by the taxpayer's conduct, etc., but it's to exert pressure and punish breaches. Finally, in relation to ground one, I think I do need to deal with doorstep dispensary, not merely because of the composition of the court, but because of some of the broad dicta in there. It's volume 2.
In case it's of interest, I had a look this morning to see what was before us in doorstep dispensary, and for whatever reason, we didn't have any Article 6 issue raised before us. I think there'd been reference to Article 6 in a lower tribunal on a different point, but it didn't come up before us.
Well, that in short what I need to say in many ways. Because it relied to a degree, citing Justice Carnwath in Khan, where the same problem arises, that there's been no proper consideration of Article 6.2, and therefore doorstep dispensary makes statements of principle without having the benefit of having its attention addressed to what on any view is an extremely important consideration in terms of burdens of proof, and relies upon a case which in turn have the same difficulty. So I would submit that given the lack of assistance which the court was given, it's always convenient to blame counsel, so I will. The lack of assistance the court was given, it should be regarded as a case, certainly as far as tax cases are concerned, is confined to its own facts.
I'm not sure this takes us any further, but I mean, when one tries to understand why counsel, who I think do have experience in human rights matters, didn't raise the point, maybe they didn't think it was going to work.
Well,
It was 162 of the Upper Tribunal decision. The burden of proof point was taken and decided upon directly, the very point that we're arguing on, and then it just wasn't pursued at the Court of Appeal. So the very point was argued at the Upper Tribunal, but then not pursued.
The Article 6 point was argued at the Upper Tribunal.
Yes, paragraph 162.
Yes, I see.
well, so
Yes. So for whatever reason, it wasn't pursued before us.
no, it wasn't before you, and that's what I'm concerned with in
Yes.
this case. So, can I then summarise it in relation to ground one? Firstly, we submit that there's clearly no ambiguity that in relation to appeals concerning penalties and consequential personal liability notices, Article 6 applies. That the burden lies upon the state to establish that there's some factual basis for liability, in this case, that the global held or supplied goods in the UK, and that is a necessary prerequisite to get the case off the ground. It follows, in any event, from the wordings of the statutory provisions to which I've taken you. It in our submissions flows from the fact that a burden of proof is put upon the taxpayer under Schedule 41, which was described as being part of a unitary code. And this, that while the shift in the burden of proof, if that is what is operative in this case, can be justified in certain circumstances, and won't offend against Article 6. But those circumstances only arise where the necessary preconditions have been demonstrated. To hold that the starting point as assessment can be made, it's then for the taxpayer to show the necessary factual conditions don't exist, is too far of a derogation from Article 6.2 guarantee. And if I can just give you the note, we've dealt with this in some detail in our skeleton argument at paragraphs 4.35 to 37, core bundle 59 to 60. And in looking at whether a reverse burden would be appropriate in this case, we say as follows: the imposition in this case of a burden to disprove the liability to penalties would be unreasonable and disproportionate outside the reasonable limits envisaged by the European Convention and Court, and in breach of the presumption of innocence. Prior to issuing a civil penalty, HMRC must have the evidence in its possession to justify the penalty, as its own explanatory notes make clear. it's best placed to deploy that evidence to prove its allegations. Requiring a taxpayer to disprove criminal allegations made by the state without insisting on a foundational proof that we've described is inherently unfair. Where penalties were described by the Upper Tribunal as significant, exceed 30 million, as in this case, the situation becomes even more stark. They were dependent upon allegations of dishonesty and fraud, because this is deliberate conduct which was alleged, which carries substantial moral opprobrium and reputational damages, as evidenced by the fact that the appellants insist on referring to Mr Malde as a fraudster. The Upper Tribunal was correct to conclude that such penalties and the underlying factual foundations for them was not of a regulatory nature. Now, although the ground 2, which is in relation to the registration liability appeal, seems to us essentially to have been covered by the arguments we've already examined so far. And I'm not sure that there's anything that one can usefully add at this stage to them. I'd invite you in any event in due course to read through part 5 of our skeleton argument. I'm sure you've already read it once. But our points about severability, our points about burden of proof, etc., all we submit are of force in this. And in those circumstances, unless there's anything I can assist you with further.
I mean, it is very much about severability, isn't
Yes,
it?
it is. Those are our submissions on grounds 1 and to the extent necessary ground 2.
Yes.
As I indicated, I was going to ask my learned friend and Mr Gurney to deal with ground 3. Do you want me? Yes. Thank you.
Thank you very much, Mr Gurney.
My lords, the appellant's ground 3 requires this court to determine whether there is any error of law in the Upper Tribunal's approach to assessing the materiality of the error of law that it found the FTT had made in its determination of the issue of whether Global had supplied goods in the UK, an issue termed the place of supply issue, which was HMRC's ground 2 before the Upper Tribunal. The appellant submits that the Upper Tribunal applied the wrong approach to determining the issue of materiality. Our submission is that there is no error of law in the Upper Tribunal's decision. Firstly, that the Upper Tribunal applied the correct test to determining materiality. And secondly, that there was no error of law in its assessment of materiality, applying that test. Before turning to our submissions, can I take the court briefly to relevant material in the core bundle that provides the background to the submissions. Firstly, to the decision of the first tier tribunal, which is in the core bundle at page 299. The court will find the tribunal's decision in respect of the place of supply issue in relation to Global between paragraphs 638 and 644. I'll come back to their reasons in a moment in a little more detail, but the ultimate finding appears at paragraph 644. Essentially, that in the absence of evidence that Global was the owner of the goods that were supplied in the United Kingdom, we are unable to find that it was liable to be registered for VAT. That's the ultimate finding. As I say, I'll come back in a little more detail to the reasons, but essentially the tribunal was not persuaded by the evidence adduced by the revenue that it was more likely than not that Global owned the goods at the time they were supplied in the United Kingdom. Turning then to the Upper Tribunal's decision in respect of place of supply. That is in the same bundle at page 111. The reasoning begins at paragraph 141 and flows through to 148. And at 141, the Upper Tribunal recognised that there were case management reasons why there was merit in determining place of supply before control. But at 142, the Upper Tribunal identified where the FTT fell into error because its approach in doing so ran the risk of compartmentalising the evidence and thereby placing the tribunal in breach of its duty to consider the totality of the evidence, contrary to the guidance in CCA and Davis and Dan. So because of that error of approach, the Upper Tribunal identified at 147 an error of law in the decision. Having found the error of law, the Upper Tribunal then applied section 12, which provides it with a discretion. Having identified the error of law, the tribunal must make an assessment of whether or not it is material. For my Lord's note, section 12 appears, I don't take the court to it, but it appears in volume 1 of the authorities bundle at page 229. It provides that the Upper Tribunal may, but need not, set aside the decision of the first tier tribunal if it finds the making of the decision concerning error on a point of law. Can I deal then with our first submission that the Upper Tribunal applied the correct test in relation to the issue of materiality in applying section 12? First, can I address the test of materiality, and then I'll take the court to the Upper Tribunal's decision to demonstrate that it applied that test. In terms of the test to be applied, it may be, in light of the court's observations yesterday, that I can take this quite shortly, but in my submission, the test of materiality to be applied is to ask whether the decision might have been different had the tribunal considered the issue on the correct basis. That test can be discerned from the decision of this court in Thomas and Merthyr Tydfil Cars. That case appears in the third authorities bundle behind tab 40, 857. It is not a case that purports to provide any guidance on the test of materiality, but it is cited by the appellants and provides a helpful example, perhaps, of the application of the test in circumstances where an error of law has been identified. Just taking the court briefly to the relevant paragraphs, at page 860, the court identifies ground 1, which is the relevant ground in the appeal, which was whether the judge erred in law in his approach to the evidence of 8 witnesses whose statements were relied upon by the appellant but who by agreement were not called. Turning over the page to paragraph 13 of the judgment, at the bottom of that paragraph, the court identified it had come to the clear view that the meaning intended by the judge was, as the appellant submits, that he attached little weight to the statements of other residents because they were untested by cross-examination, and then at the top of 14 the court identified that as an error of law. And the test of materiality can then be discerned at paragraph 15, where the court then went on to consider the effect of that error of law and the effect it may have had on the judge's reasoning and conclusions. The court observes that the evidence was clearly relevant generally to the issues in this case, and it is necessary to consider whether the judge's decision to attach little weight to this category of evidence has been material to the outcome, and in particular whether the outcome might have been different had the judge considered the evidence on the correct basis. And clearly in that case the court went on to explain why it felt confident that the right approach wouldn't have led to a different conclusion. But of course, it's very highly fact sensitive, and the court has to determine the application of that test to the error of law identified by the Upper Tribunal in this case. Can I turn then to the Upper Tribunal's decision to make out the submission that it applied that test in determining the question of materiality of ground 2? We are back in the core bundle, please, I think where we left at page 113. At paragraph 148, the court identified the reasons why it did not consider it appropriate to set aside the decision of the first tier tribunal as a result of its error of law. I'm going to return in due course to deal with the detailed reasons, but can I just draw the court's attention to the final sentence of paragraph 148.1, where the court identifies at the end of its first reason, it is difficult to see how this result would have been any different if the FTT had decided that Mr Malde did or did not have control of Global before addressing the place of supply issue. That's the framing of the test by the Upper Tribunal, and the court can see some light is shed on the Upper Tribunal's approach in its permission decision, which appears in the same bundle at page 147.
So just give me a moment.
Cool. The decision starts at 143. The relevant section in relation to ground 3 is at page 147. At paragraph 17, the Upper Tribunal made the following observations. We do not find the appellant's arguments in relation to this ground of appeal particularly compelling. The two cases the appellant cites in support of a more objective approach do not appear to us to reach conclusions that are inconsistent with our approach. And there they cite Merthyr Tydfil and Thomas. And they go on to say the first tier tribunal decided the place of supply issue by reference to the burden of proof. In this case, there is no reason to suggest that whatever conclusion the FTT had reached on the question of control of Global, such conclusion would have affected its conclusion on the place of supply issue. In our submission, it's clear that the Upper Tribunal was applying the test set out in Thomas and Merthyr Tydfil, and the court can see the Upper Tribunal's expressed a view that, having considered Thomas and its decision on materiality, was not inconsistent with the approach in that case. The Upper Tribunal answered the correct question of whether the first tier tribunal might have determined that Global supplied the goods in the UK had it decided that Mr Malde was in control of Global. So in my submission, the Upper Tribunal answered the correct question. Malone Friends' submissions appear to be that the Upper Tribunal applied the wrong approach. Malone Friends submits that the question, which is the way it's phrased in the skeleton argument, that the question is whether the error is objectively capable of being material, rather than focusing, as they put it, on whether it was material to what was an already tainted decision. There is no authority relied upon for that submission. The test in our submission is clearly set out in Thomas. There's no reference in Thomas to any assessment of whether the evidence was, or whether the error was objectively capable of affecting the decision. The focus in that case was on whether it could have led the judge to a different view. In our submission, the point of the materiality test in Thomas is to remove the error of law from consideration and to ask whether the decision might have been different had the error of law not been made. It follows that in applying that test, the Upper Tribunal was no longer looking at a tainted decision. It was looking at a decision without the error of law that it had found the FTT had made. So in our submission, the approach the Upper Tribunal applied was the correct one in applying the test of Thomas. Before leaving the permission decision, I just draw the court's attention to paragraph 18, in which this was forgive me, at page 147, paragraph 18, having already expressed its view that the appellant's arguments were not compelling, the Upper Tribunal went on to observe that if ground 3 had been the sole ground of appeal, they would not have been minded to grant permission to appeal. And the reason they did was because the issue related to the place of supply issue, and having granted permission on grounds 1 and 2, it was felt that it would limit the matters that this court could consider if it refused permission on ground 3. So I simply observe that in passing for the court's consideration. Can I turn then to deal with our second submission, which was that in applying the test of materiality outlined in the case of Thomas, that there was no error of law in the Upper Tribunal's application of it and its assessment of materiality. We'll return to the Upper Tribunal's decision in a moment, but our submission is that the Upper Tribunal identified in paragraph 148, to which we'll return in a moment, 2 reasons why it did not consider the error of law it had identified as being material to the first-tier tribunal's decision. It is notable that Malone and Friend in his submissions to this court only addressed the first reason given by the Upper Tribunal, which is at 1481, and made no submissions on the second reason. We would observe that the appellant's partial approach in focusing only on one of the 2 reasons may explain why they criticise the Upper Tribunal's assessment of materiality. The 2 reasons must be considered alongside each other. If we can turn then to the reasons, it's page 113 in the core bundle, paragraph 148. Before I read those passages, we would also urge caution in looking at those passages and dividing them up sentence by sentence. There was a tendency in the appellant's submissions to take a sentence and to make submissions that it reflected something in the Upper Tribunal's approach. In our submission, there should be caution about that, and the court should look at the paragraphs as a whole and consider what it was that the Upper Tribunal was saying. The reasons that the Upper Tribunal gives in 1481 and 2 can, I hope, be summarised in 2 simple conclusions. The first, at 1481, was its conclusion that the first-tier tribunal's finding, following its assessment of the evidence, was that HMRC had failed to prove that Global was the owner of the goods supplied in the UK, rather than them having been sold on the continent. So the first reason, if I can put it this way, was a failure of the appellants to discharge the burden of proof. The second reason, which is important and has to be considered alongside that first reason, is that the first-tier tribunal had rejected Mr Malde's evidence. The tribunal did not regard him as a reliable or a credible witness, and so there was no reason to think, as the Upper Tribunal said, that the first tribunal's failure to consider the question of control would have had any material effect on its view of his credibility or the evidence that he had advanced. So the second reason is the credibility assessment of Mr Malde and his evidence. In our submission, when those 2 reasons are viewed together, those reasons provide a sound basis for the Upper Tribunal's conclusion that the error of law was not material to the first-tier tribunal's decision.
So you say the Upper Tribunal was entitled to arrive at that view, whether or not it could have taken a different view?
Yes, there's no. There is no error of law in its approach. It applied the correct test, and the assessment that it made was right.
Now, just to explore what I think Mr Hayhurst says, he says, well, supposing the Upper Tribunal supposing the first-tier tribunal, before deciding on place of supply, had decided that Mr Malde controlled Global, then it would have been able to take into account the fact that he should have been able to provide details of what was going on, which he couldn't do if he wasn't in control. So what's the position in relation to that?
Well, I think the revenue raise the question of whether or not, if control had been found against Mr Malde, they suggest he might have been expected to produce evidence to support, they say, his assertion as to place of supply, and in not doing so, that would have undermined the veracity of his case. So it would have impacted upon credibility of his case and what he put forward. I think was the
Or
way in
putting it
which-
the other way around, the fact that he hadn't supplied the information when he was in control would have been something that the first tier tribunal would or might wish to factor into deciding the place of supply issue.
In terms of whether or not the failure to produce records could have been directly relevant to the question of place of supply and so supported the revenues case, it's right to say that it's possible that the FTT could have drawn an inference against him on that issue, would have been open to them, but it's something that in our submission they would have had to have been very cautious in doing so, because in considering whether an inference would be appropriate, they would inevitably have to consider whether there was any other credible explanation for the failure to produce the records. This, of course, is against the background of his case that he wasn't in control. The records that we're talking about, the records relating to the trading of Sintra Global, the inference they would have sought the tribunal to draw was that had they been produced, they would have proved that supplies took place in the UK, as against the possibility they would in fact have shown supplies in the EU. The difficulty with the tribunal drawing that inference is that there is an equally credible explanation for the failure to produce those records, assuming he was in control of the company, because if the records in fact showed trade in the EU, they would have been equally prejudicial to the company and to Mr Malde, and so there were good reasons not to produce them, whatever they showed, whether they showed trade in the UK, trade in the EU, against the background of the tribunal's findings and the evidence that these sales in the EU were part of a smuggling operation. It would have been very difficult in our submission, and the tribunal would have had to have been extremely cautious in doing so, to draw the inference for which the revenue contended.
Yeah.
So in our submission, had the tribunal made an explicit determination of control, the inference going to place of supply directly is not one that realistically would have been open to them on a fair assessment of the competing submissions, and any finding of control could not have impacted upon Mr Malde's credibility, which had been roundly rejected by the FTT in the course of its decision. This was not a case where, as might be the situation, where credible evidence from the taxpayer had tipped the case in its favour, set against compelling evidence from the revenue. That this was a case where the revenue failed to discharge the burden, the tribunal having found it fell on them, and Mr Malde's evidence was rejected wholesale by the tribunal. Can I then address some of Malone and Friends' submissions and taking them in turn? The first is the, if I can put it this way, the borderline submission. Malone and Friends submitted that because this case, his words, hinged on the burden of proof, it could be characterised as borderline or not clear cut. And he referred you to the case of CCA for his submission that in a borderline case, an irrelevant consideration being taken into account, or failure to take account of a relevant consideration of any weight, would be material to the decision. In our submission, the appellants are wrong to describe this as a borderline case. As to the comparison with CCA, we simply observe that CCA in the tribunal was a split decision. The two members of the tribunal reached different views as to the issues before them, and the judge who found the case, who had the casting vote, described it as a borderline case. So one can see why the Court of Appeal approached the case in the way that it did. There is nothing in the tribunal's reasoning in this case that suggests that this was a finely balanced decision. I've already taken the court to the tribunal's conclusion. It was summarised by the Upper Tribunal, paragraph 48 of its decision. The FTT decided HMRC had not discharged its burden of proof to show that Global made supplies of alcohol in the UK. The simple conclusion that can be drawn from the decision is that the appellants didn't discharge the burden of proof upon them. The Upper Tribunal described it as there being an absence of evidence that Global was the owner of the goods. And that lack of evidence was a fundamental weakness in the appellant's case, and it had been from the inception of the case, and it was a fundamental weakness that was exposed during the course of the hearing before the tribunal. But in our submission, a finding that the revenue had failed to prove its case does not make this in any sense borderline. The tribunal never described the case in that way, and nor did the Upper Tribunal in its assessment. So in our submission, the court should reject that suggestion by the revenue. The second submission that we seek to address is my learned friend seeks to challenge the Upper Tribunal's exposition in paragraph 148 of the reasons for the first tier tribunal's finding on place of supply. There are, if I can perhaps take the tribunal, if you're not still there, to the core bundle, page 113, paragraph 148, which are the reasons on materiality.
Sorry, I wasn't keeping
Page
up.
113.
113. Oh, yes.
Paragraph 148, and
Yes.
we're focused here on the first paragraph within 148, and the Upper Tribunal's assessment of the reasons. That it observes firstly that the issue of place of supply was determined on a basis which had little connection with the issue of control. In relation to Global, the FTT decided the place of supply issue on the basis that HMRC had failed to prove that Global was the owner of the goods supplied in the UK. And then it identifies the main reasons in its assessment for this failure were, one, the evidence of payments to Global by various companies for the alcohol supplied by Global, and two, the evidence that other entities were involved in the supply chains that HMRC's analysis ignored. The FTT were not prepared to disregard that evidence, which in turn called into question the place of supply by Global. HMRC had failed to prove that these sales involved the supply of alcohol by Global in the UK as opposed to on the continent. Malone and Friends' submissions sought to criticise that assessment by the Upper Tribunal in its reference at Roman numeral 1 to evidence of payments being a reason for HMRC's failure to prove that Global was the owner of the goods sold in the UK. HMRC's submission is that evidence of payments was simply used to narrow down the issues rather than being a reason that HMRC failed to prove its case. In our submission, the appellants are wrong, and that was a factor in the FTT's decision. Can I take the court to the FTT's decision, please? Page 299 in the core bundle. And the consideration of place of supply begins at paragraph 638. Malone and Friend took you to 638, where it set out where the tribunal set out an extract from our closing submissions on behalf of the taxpayers, which dealt with the question of payments and identified the crucial issue as being, as described above, where the supplies happened, given that there were undisputed payments made to Global from these companies. We agree that evidence of payments narrowed down the issues, and that evidence was the basis for our concession that Global had owned the goods at some point, which were ultimately smuggled. But the point went further. If the court looks to the next paragraph, paragraph 639, the tribunal deals with the submissions made by Mr McGuinness, King's Counsel, who then represented the revenue. And the final sentence of that paragraph is relevant. It was HMRC's submission to the tribunal that the Banjacks convictions, and that is convictions in relation to the companies named in paragraph 638, so most of those companies anyway, he says that the Banjacks convictions and the money flows that have been proven to have taken place are, the revenue said, potent evidence that Global was a smuggler of alcohol that it supplied, not by some innocent intermediary in the UK for which it received payments. That was the revenue's argument. We sought in the tribunal to demonstrate the fallacy of that submission, and ultimately the tribunal, in its decision, didn't agree with the submission of the revenue, because the revenue, having submitted that the evidence of payments was potent evidence that Global was the smuggler, ultimately the conclusion of the FTT was to reject their case and to conclude that there wasn't evidence to prove that Global retained the goods at the border. And so we say that the evidence of payments was a main reason why the FTT rejected the revenues case. And so the Upper Tribunal was right to identify it in 1481 as being one of the main reasons why the FTT found that HMRC had failed to discharge the burden of proof. The second main reason that's identified by the Upper Tribunal at Roman 2, if we go back, please, to the Upper Tribunal's decision, page 113, the second main reason identified in paragraph 1 is the evidence concerning other entities involved in the supply chain, and the fact that HMRC had ignored those in their analysis, other entities between Global and the ultimate UK customers. And it's accepted by my learned friend that that was a factor in the FTT's decision, and that had been a decision to ignore those entities, which were company legal entities, to ignore their position and to assess Sintra in respect of the tax and VAT was a fundamental flaw in the appellant's case. And it's apparent from the FTT's reasons that it was not prepared to ignore those companies as the revenue wished them to. And that was clearly one of the main reasons it rejected the case. So our submission is that in respect of my learned friend's criticisms of the Upper Tribunal and its reasoning in 1481, that there can be no proper criticism of the way in which the Upper Tribunal characterised the main reasons for the FTT's decision. Can I turn then to, having dealt with the question of the potential adverse inference which might have supported the revenue case, can I turn then to my learned friend's submission that had control been found against Mr Malde, that it would have undermined the veracity of his case, impacted upon his case, and so the revenue submit was a highly relevant factor for the tribunal to take into account in respect of place of supply. The arguments that the revenue mount in this regard are in line with the reasons the Upper Tribunal gave for finding an error of law in the first place. So the Upper Tribunal was clearly alive to the fact that there was potential relevance of the issue of control, because that's why it found there was an error of law. But the reasons the Upper Tribunal gave are sound as to why, although there was an error, there is no materiality in it. There are 3 points in my submission relevant to that assessment of materiality. The first is that it's important to understand the evidence that Mr Malde gave before the tribunal. There is a tendency on the part of the commissioners to focus on his case before the tribunal as being an assertion that goods were supplied in the EU. That was not the case. His case, as the court knows, was that he had nothing to do with the trading of either SA or Global. He claimed to have no idea where any supplies took place. And his evidence quite simply was, I wasn't in control, I don't know where the trading happened. So there was never any assertion by him, as has been suggested, that supplies took place outside the UK, in the EU. On his behalf, we sought to undermine HMRC's case, their assertion that supplies occurred inside the UK. That was and the decision of the FTT in finding that they hadn't proved their case was because of efforts to undermine their evidence rather than any assertion by him as to place of supply. The second point, when considering materiality, and perhaps the most significant one, is that it is apparent from the FTT's decision that any explicit finding of control would have had, in our submission, no impact at all on his credibility before the tribunal as a witness, because his evidence had already been roundly rejected by them. And that, of course, is the second reason given by the Upper Tribunal in 148 as to why the error of law was not material. Can I briefly take the court to passages of the FTT's decision that show its conclusions about Mr Malde's evidence? They begin in the core bundle at page 190. The structure of the decision, as the court will have seen, was to deal with the witness evidence first, and to summarise at least some of their conclusions in respect of that witness evidence as the tribunal went through before turning to the disputed issues. Paragraph 83, there is the heading Pearl Malde, and the tribunal said at 83, Mr Malde, the second appellant in these proceedings, gave evidence in person and was cross-examined over 9 days. When questioned, he was frequently unable to recall matters, particularly if these related to a matter that was potentially adverse to his case. However, he was able to recollect, often in granular detail, other events that had taken place around the same time. Much of his evidence, especially in relation to SA, Global, Pat Somnopol and Arno Carre, and I pause to say that those were relevant people in respect of Sintra and the operation and management of it, was inconsistent with statements he'd previously made in interviews and or correspondence, and as such casts serious doubt as to its veracity. The tribunal went on, and I'm not going to take the court through them, but from 84 through until 94, the tribunal set out a number of examples that provided the foundation for that general expression of its assessment of his evidence at paragraph 83. There are numerous examples where the tribunal found his evidence was internally inconsistent or inconsistent with other documents or otherwise unreliable or incredible. A number of those examples related to his evidence about the ownership and management of SA and Global, so directly relevant to the question of control. For the court's note, again, I won't take the court to them, but other relevant paragraphs are 218 and 220, where the court dealt with issues about control and identified inconsistencies in Mr Malde's evidence as to whether or not he had been a director of the company, and noting an absence of evidence to corroborate his claims about ceasing to be a director. And at paragraph 230, the tribunal noted inconsistencies between a concession he made in evidence and an earlier assertion he had nothing to do with Sintra SA's bank account. So those were a number of specific paragraphs which demonstrated it was clear that by the time the tribunal came to determine the question of place of supply, which appears at paragraph 606 in the decision, it had rejected Mr Malde's evidence as lacking credibility and had expressed serious doubts about his veracity, as the court has seen. When it came to address the question of place of supply, it dealt with SA first before turning to Global, Global being the relevant company for the purposes of this court's assessment. And in addressing the question of place of supply, it made further adverse findings against him. And again, for the court's note, paragraph 632, the tribunal rejected his evidence about attribution of various telephone numbers, save for one number, finding that HMRC was right to attribute those numbers to him. When it came to deal at paragraph 644 with the question of place of supply and its decision in respect of global, and there can be no doubt that Mr Malde's credibility had been roundly rejected by the tribunal. And it's our submission that given the adverse conclusions the tribunal had reached about his credibility, that the upper tribunal was correct to conclude that an explicit finding on control in relation to global would not have undermined any further the FTT's assessment of his credibility and would not have had any bearing on its decision about place of supply. The third point is this. It's clear from the decision, when the FTT did come to deal with the question of control of SA, the FTT expressly rejected Mr Malde's account in respect of control of that company. The FTT concluded he was the controlling mind behind SA. There was, on his evidence, no distinction between the two. It was accepted by him that essentially they were the same company. He saw no distinction between them. And given the tribunal's wholesale rejection of his evidence, it is overwhelmingly likely that the FTT reached the same conclusion in relation to control of global, albeit it was never expressed explicitly in the decision because it was unnecessary for it to do so, given its decision on place of supply. So it's reading decisions in the order in which they're expressed, of course, is how they must be read. But by the time that the tribunal came to make its decision on place of supply, we say it had already addressed his credibility, already rejected it, and then one can see the conclusions it reached on the global question of control when it comes to deal with it in respect of SA. And it's inconceivable it would have come to any other conclusion in respect of global. The final point, my lords, is to deal with the question, the documents to which you were taken yesterday. My learned friend took you to a series of 7 documents on which he relied, and he said to show the significance of the issue of control to the issue of place of supply. We simply seek to make some observations in respect of those. My learned friend suggests that those documents are important because he submits they gave rise to difficult questions for Mr Malde to answer, and the answers to those questions and the way he gave his evidence were relevant, they say, to the veracity of his account. We accept that each of those documents was relevant to the issue of whether there was alcohol being smuggled into the UK and by who. For this court, importantly, each of those documents was in evidence before the tribunal. As my lord observed yesterday, there was extensive cross-examination of Mr Malde, as the tribunal observed, over the course of 9 days, and he was questioned extensively about all of that material. And it was suggested to him in cross-examination that he was responsible for the smuggling operation, and it was suggested that he was denying being in control because he couldn't produce any evidence that could support his case. So by the time the FTT came to assess the issue of place of supply, no doubt in large part because of that cross-examination over 9 days, the tribunal had rejected his evidence. And so whilst those documents are relevant, they were clearly considered by the first tier tribunal, and in our submission there's no reason to think that making an explicit finding on control of global would have changed the tribunal's conclusion about place of supply. So to conclude, our submissions are, as I've said, that there was no error of law in the upper tribunal's approach, and its conclusion that the failure to determine control would have made no difference to the FTT's finding, for the reasons that I've outlined.
And I don't accept any questions, so thank you very much, Mr Gurney.
My lord, I did threaten you with a further case earlier on. It's now arrived in hard copy.
Yes.
And I would ask for leave to refer to it,
Yes.
not least of all because you'll see it's on exactly the same points made by the same counsel in which the tribunal found against him. So if I can hand those in, please. Yes, I'm sorry about the highlighting. I'm sure you can intellectually disregard it. It was done at rather short notice.
Yes.
So, my lords, This is a case from the first tier tribunal, so of course it's not in any way binding on this court, but you've been referred to a number of them as being of persuasive authority. So you can see that my learned friend Mr Bednam, King's Counsel, appeared for the appellant, and my learned friend Mr Hayhurst represented Revenue and Customs. And paragraphs 1 and 2 make it clear that this was a case in relation to an application for disclosure. My learned friend referred to it tangentially yesterday without providing the case itself, but we now have it. It's a case in which there was a denial of input tax under Kittle, but also a £2.5 million penalty under section 69 of the Value Added Tax Act. And the issues being addressed here is whether or not, and to what extent, there was an obligation to disclose. Mr Benham advanced his arguments, and if we can look at what the Revenue was saying, we find it on page 5 of the report, paragraph 13. Mr Hayhurst, paragraph point 2, when a Kittle input tax denial and tax assessment are heard concurrent with a VAT appeal, penalty appeal, Mr Hayhurst avers that Article 6 doesn't apply to the input tax denial assessment component of the 69 penalty. Mr Hayhurst submits that Article 6 is only engaged as regards those specific conditions that have to be fulfilled for the imposition of a penalty which relate to the criminal charge. Mr Hayhurst says that in part this is due to questions of practicality. As a practical matter, when an underlying tax liability appeal is heard together with an accompanying penalty, the tribunal determines the underlying tax liability first, which doesn't engage Article 6, before going on to consider the penalty where Article 6 is engaged. Mr Hayhurst states that if HMRC is successful with respect to the question of underlying liability, that outcome as to liability passports forward to the penalty appeal without being relitigated. He then cites cases that we've looked at, Jasilla, King against the United Kingdom and Omar Minerals, and at number 8 at the top of the next page, if it is possible to separate, Mr Hayhurst's position is that Article 6 is engaged only as regards those conditions that have to be fulfilled for the imposition of a penalty and which relate to the criminal charge. Paragraph 10, or number 10, Mr Hayhurst also suggests that in the case of Sintra, the Upper Tribunal recently confirmed that in concurrent proceedings, Article 6 does not apply to the tax liability component of a penalty. If, when you come to consider that, you look at paragraph 125 of their decision, page 108 of the core bundle, you will find that is not easy a submission to reconcile with what the Upper Tribunal said. The main issue in that case, he goes on to submit, was slightly different, namely whether Article 6 applied to a penalty alone scenario, where the underlying liability has not previously been determined, was not heard concurrently with the penalty, the taxpayer unchallenged the underlying taxability in the context of penalty litigation. The Upper Tribunal ruled that Article 6 did apply to the tax liability component of the penalty in that scenario. However, Mr Hayhurst said we've appealed that. And then paragraph 14 from the above. Mr Hayhurst argues the tribunal ought to recognise 3 distinct categories of case. Category 1, separate liability appeal and penalty appeal proceedings. Mr Hayhurst submits that when a tax liability is decided by itself, it may be an abusive process for the taxpayer to seek to rely on Article 6 in order to relitigate the liability in subsequent separate penalty proceedings. Category 2, the underlying liability and the penalty are heard together, as in the present case. Mr Hayhurst argues that Article 6 should only apply to the penalty insofar as the same issues do not overlap with the underlying liability. Category 3, penalty cases alone. There are cases where litigation only concerns a penalty and there's been no separate appeal as to the underlying liability. In such cases, Mr Hayhurst accepts that Article 6 would apply to the underlying liability as well as the penalty. Then at paragraph 18, echoing to a degree what's been argued before my lords, Mr Hayhurst's arguments on this point is that while penalty assessments are regarded as criminal proceedings for the purpose of Article 6, they don't fall within the hardcore of the criminal law. The requirements of Article 6 don't apply with their full stringency. He referred to a case called Booth against HMRC to support the submission that what is required is a broad assessment of whether the particular charge brought against the appellant is dealt with in a manner which provides a fair hearing when the proceedings are viewed as a whole. And then the learned tribunal judge went on to consider these paragraphs 31 onwards. The right to a fair trial is a human right. In my view, the tribunal ought to enable the exercise of such rights, unless doing so infringes on the rights of others or is disproportionate. Effectively, would agree with what Lord Bingham said in Sheldrake. In my view, Mr Hayhurst's contention that Article 6 rights ought only to be available in relation to penalty-specific condition lacks a sound footing. The authorities he cites may support a suggestion that when criminal charges can be separated from other matters, that Article 6 only applies to criminal charges. That seems uncontroversial. However, I see no basis in authority for the suggestion that where there's an overlap between criminal charges and other matters, that the result ought to be that Article 6 doesn't apply to the areas of overlap. In particular, the case of Sintra relied upon by Mr Hayhurst concerns the position where there's no appeal in relation to the underlying liability such that Article 6 applies to all aspects. Well, that may be a misanalysis there. It does not, so far as I understand, provide support for the proposition argued for by Mr Hayhurst. He then looks at the case of King, and then finally this. Article 6 rights are fundamental rights to be enjoyed by all of those who are the subject of a criminal charge. To suggest that such rights can be removed or diminished simply because another matter doesn't have Article 6 protection is being heard concurrently suggests that human rights are merely a matter of convenience. This cannot be correct. So we draw this to the tribunal's attention. You'll see the way it was argued, and you'll see the result. And more than that, I don't wish to say.
Yeah, thank you very much. Thank you very much. Mr Hayhurst.
My lords, those instructing have asked whether they can discuss some matters with me and give instructions, and would it be possible to have an early lunch?
Yes.
If that pleases the lords.
Yes. Fine. So in that case, we'll come back at 1:30.
Both rise if able.